straight up, we cannot have an appreciation or understanding of the respondent's reply to the petition of the Labour Party and Obi if we don't understand the very foundation, the very heart of his petition. So the starting point for me is what is constitutive of Obi's petition filed before the PET in Abuja. Obi's petition is founded on two fundamental planks. One, the qualification or disqualification of the president-elect or presidential candidate of the APC, Alhaji Bola Ahmed Tinubu, at one level. These ground of Obi's petition is founded on Section 137, 1D of the Constitution 1999. In the course of our conversation, I will go into what 137 is all about. And two, the disqualification, if you like, of the vice presidential candidate or vice president-elect of the APC, Alhaji Shettima, more particularly as it relates to the issue of double nomination as provided for in Section 35 of the Electoral Act. And the second fundamental limb or plank of Obi's petition is founded on the whole argument about the non-substantial compliance of INEC with the provisions of the Electoral Act as it regards the conduct of the February 25th presidential elections. While the second one deals with facts and law, facts and law, or what lawyers call mixed facts and law. You cannot say elections was not, the conduct of an election was not in substantial compliance with the law if you don't found your argument around facts. What are the facts? That elections took place across the length and breadth of our country, on that particular Saturday. Elections were returned in certain polling units across our country. Elections were not returned. Elections were rigged. When you bring criminality into the whole question of election petition, you are raising the bar. And the strictest proof will be on you who is alleging criminality. That's the second limb. But the first limb is not a matter of fact, it's a matter of law. And the position of Obi is founded on the whole question of forfeiture that took place in America 29 years ago. The whole business of white powder trafficking and all that. And the order of court, or the Illinois court in Chicago, that made the order of forfeiture. The argument here is this: does forfeiture fall within the ambit of Section 1371D of the Constitution? The Constitution does not, in specificity, refer to forfeiture. It talks about fines. It talks about fine. Can fine mean forfeiture? But we have seen Supreme Court decisions placed in the public space in our country, particularly the Supreme Court decision in which the CJN of Nigeria, Justice Ariwola, read a lead judgment where he basically quoted forfeiture around the whole context of fine. When you forgo something, it comes within the whole business of fine. So that is the entire argument of Obi. But if you look at Section 137, 1D, and I have always made the argument that the disqualification grounds in Section 1371D is not one. There are 6 disqualifying grounds because each ground is separated by the conjunction or, where it says fine, it says or fraud. When it says death sentence imposed by any court, it says or tribunal. So if you count the number of us in subsection 1D of Section 136, you are looking at 6 disqualifying grounds. Then if you move further to subsection 1E, where it talks about the question of fine must have been imposed between a period of 10 years preceding the elections that presidential candidate is expected to run. And if you look at the beginning of section 1E, for those who have the constitution there, the last word that separates 1D from 1E is a semicolon. It's a semicolon. And after the semicolon, it begins with all. So what that means is that section 1E, the disqualifying ground in section 1E is separate from those 6 disqualifying grounds that are outlined in subsection 1D of section 137. So having this in view, I have to go to the respondent reply.
Yeah.
The